Wait, please, Your Lordship. Lordship, I beg to mention item number 5, Your Lordship.
5, yeah.
Lordship, some instructions are awaited, Your Lordship. I pray that the matter may be listed after 3 weeks, Your Lordship.
Yes, look here, the request of the learning council for the
Appellant, Your Lordship.
applicant. List this matter. Is this matter for after 3 weeks?
Yes.
Yes.
Much obliged.
Lordship, I beg to mention item number 7 and 8
Yeah.
with the consent of the other side. The leading counsel, Abhay Kashyap, is out of the country, so maybe listed after 2
Urgent.
weeks.
Urgent.
Obliged.
Yes.
May I please, Your Lordship? I'm praying for listing on matter, Your Lordship. Last it was listed on 5/9/2024. But that no such date has been fixed.
9/5/2023.
24, Your Lordship. In
Okay.
this month only, the urgency is that, Your Lordship, matter relates to settlement of market, Your Lordship. And 30 June is the last date of.
If June is the last, then 29th.
Obliged.
Back to you, Lordship. Lordship, I beg to mention one, the IA mallet in retail number 127 mallet. So this IA was filed on 28th of 18th of April 2024.
IA for what?
IA mallet, the person is going to be retired and this is for promotion matter mallet.
When he is going to retire?
This October mallet,
October,
this mallet. So
June 2nd week. June 2nd week. June 2nd week.
mallet, can it be otherwise? Only IA mallet. Since in retail mallet, the notice was issued. And the IA was found to be somewhere defective mallet. That has been already corrected by your lordship's mallet.
So IA for what?
IA mallet, since one representation is pending before the authority concerned,
Fine.
and that can be considered a pendency of the retail mallet. Since
So it will be come on June, in June 2nd week. No problem.
can it be earlier mallet? I pray mallet. I pray mallet.
Yes, then get it listed on 6th of June.
Lordship. Okay.
Yes.
My lord, there is an item 55 in the part 2 hearing list.
Okay.
If that may be heard at your lordship's convenience at any particular date.
June 1st.
Review petition in this was already allowed.
Get that. Yeah.
Much obliged.
Your Lordship, I'd like to mention a writ appeal for listing on 3rd of June.
Why? So 3rd on June, specific date?
Because the council will be coming from outside here.
Okay, 3rd June.
Daily list for orders item 1.
My pleasure, Lordship. Madam, this.
Madam, the government is supposed to make the payment.
Yes,
No,
lordship,
I will
we
receive-
have,
We received only, my lord, a sum of 1,77,000, my lord.
How much due amount of
Because in the rate petition, it was 21 lakhs, my lord.
21 lakhs?
My lord.
Lordship, we have paid the amount which SLP has decided, Lordship. Lordship, he has paying for some area salary of 40 months, Lordship, that we have already denied in our affidavit in opposition, Lordship. He will not entitled for that. He was not working for that period, Lordship.
So how much money this lady is entitled to get?
Get 1,77,000.
Only 1,77,000.
Yes, Lordship, that has been paid to him.
And you have filed this affidavit of this effect.
In this effect, I have not filed, Lordship. Yesterday, I have received an instruction, Lordship.
You filed that affidavit
Lordship.
and you filed the counter.
Lordship.
Likhe learned counsel from the state has submitted that the due payment of arrears has already been
My lord,
given to the-
figure may be quoted.
given to the petition, appellant. Full stop. Learned counsel for the appellant has submitted that only a meager amount out of total arrears have been paid to the appellant by the respondents. Full stop. the state is directed to file an affidavit regarding the calculation on the basis of which the arrears have been paid to the petitioner, appellant within a period of when
2 weeks, Lordship.
within a period of 2 weeks with the advance copy to the counsel for the respondent. The counsel for the respondent may file counter to it if required, so within a period of next 1 week, list after 3 weeks.
Deep.
Item 2 to 4.
Yes,
Lordship, I may be allowed 1 week time to obtain instruction, Lordship.
what obtain instructions we have
Lordship, regarding
direction for this who is the officer?
additional assistant commissioner.
Assistant Labor Commissioner come
Lordship.
authority to receive this amount and to disperse.
Lordship, what happened, Lordship, the attached counsel is unable to communicate with the commissioner, Lordship.
Why?
Due to his some physical problem, Lordship, so I may be allowed to 1 week time.
Yeah, and counsel appearing for the state has submitted that a week's time be granted to the Assistant Labor Commissioner come authority to move an appropriate application for receiving the amount from the registry as ordered by this court on 15/5/2024. List after a week date.
Lordship,
We are offering money and you are not taking
Lordship.
ready to.
Item 6.
The Canara Bank was supposed to file an affidavit.
We have filed, your lordship.
They have filed.
We have filed, your lordship.
You have filed.
Yes, sir.
What was the
Affidavit, your lordship, what has happened, your lordship? There is a notification by the central government that we brought to the record by filing the affidavit, your lordship.
what was that notification? What is that notification?
Notification, your lordship, where your lordship will get it at page 127,
127.
127, running page, your lordship.
Yeah.
What had happened, your lordship, in this case,
Yeah,
on 6/6/2018, there was a notification, your lordship, issued by the central government, your lordship, thereby, your lordship, enhancing the pecuniary jurisdiction of the DRTs, your lordship.
fine.
Now, your lordship, on 26/9/2018, that notification stayed by the Honorable Rajasthan High Court, your lordship, in WBC number 2186/18. Then, your lordship, in the meanwhile, your lordship, while the stay order was in operation, your lordship, the Canara Bank, your lordship, the claim was 10 lakhs, your lordship. Enhancement was from 10 lakhs to 20 lakhs. Therefore, it should ordinarily would have been filed in the civil court, your lordship. But since there is an operation of stay, your lordship, we preferred the OA in the DRT, your lordship. Now, on 1/7/2019, your lordship, the stay order was vacated, your lordship.
Fine.
Then, your lordship, there is a notification, your lordship will get the said notification, second notification at page 72.
It shall continue to apply that in respect of the application for recovery has been filed before the prior to the publication of the notification.
Lordship,
That is today, 6th day of September 2018.
lordship,
And you have filed that application prior to that.
prior to that, your lord. Now, your lordship will kindly see page 72. This is the second notification, your lordship.
Yes.
After stay was vacated by the Honorable Rajasthan High Court, your lordship, it says, but shall continue to apply to the dates in respect of which an application for recovery has been filed before the dates recovery tribunal prior to the date of publication of this notification, that is to say, 6th day of September 2018. We have filed, your lordship, during the operation of the stay, your lordship. Now, your lordship, they came up with the writ petition, your lordship. Since it is prior to 6, then, your lordship, we will have to file in DRT, your lordship. That's what their case, your lordship. And your lordship will kindly, there is a clarification, your lordship will get it at page 73.
Yes.
This clarification, your lordship, was issued by the Deputy Secretary Goptom, India, your lordship.
What they have clarified?
Page 73, your lordship. Second paragraph, a writ petition being DWCWP number so and so, titled as Kirti Kapoor versus Adar versus Union of India, had been filed before the Honorable High Court of Judicature of Rajasthan, bench at Jaipur, challenging the said notification, and by order dated 26/9/2018. And the Honorable High Court has stayed the notification number so and so, dated 6/9/2018. The said writ petition has been dismissed by the Honorable High Court of Judicature for Rajasthan, bench at Jaipur, by order dated 1/7/2019, as already informed by the email dated 5/9/2019. It is hereby clarified that the case having suit value between rupees 10 lakhs to rupees 20 lakh, which have been filed before the DRTs during the stay period from so and so, may continue in DRT till conclusion, so that no prejudice shall be caused to parties who have filed such suits in good faith. Cases filed on or after 1/7/2019 may be transferred to the civil courts and DRT.
Notice. Notice of stay, only issue notice, returnable on so and so.
They have in fact entered appearance, your lordship, in the
Who is the
private respondent, as private respondent.
Who is the bidding?
He is your lordship, as Mr. Ghosh, your lordship. A Ghosh,
But I think so his name is not there. Yeah, hey, it is there.
lordship. Now, if you, lordship,
Show the copy of the
lordship,
affidavit,
copy has been served, your lordship.
of the affidavit,
Everything, your lordship,
everything,
lordship,
affidavit.
lordship. Oh, he is coming, your lordship.
Yes,
Extremely sorry, Your Lordship. Lordship, I was for the petitioner in the.
they have submitted that
The
notification.
learned single judge. I find that he has taken a possible the right view, Your Lordship, because at the time when the application was filed by them, at that point of time, on the basis of circular.
Now they have placed on record a notification which this court has directed them to file, place on record.
Pardon, Your Lordship.
এই affidavit টো কোথায় গেছে? আমি notification from the application, latest notification from the daily affidavit.
Have you gone through that?
Now, Your Lordship, this notification, Your Lordship, is with regard to a sub event which has transpired after the award, the
Yeah,
judgment,
Mr.
single judge has
You have filed
passed.
this affidavit along with then this notification along
Yes.
with an affidavit.
Yes, Lord.
File your counter. What do you, if you want to counter it, file your counter.
But the judgment which he has assailed, Your Lordship, at that point of time, this particular circular, notification was not in existence. Now, I had already intimated the Debts Recovery Tribunal about the passing of the judgment passed by the learned single judge. Because thereafter, there was a span of, I
So
think,
you don't want to file any counter to that affidavit?
Counter to the null. Counter the only notification is the court. कोई जो हमने DNA नहीं दिया।
yes,
Mr. Biswas, are you not following? Do you want to file a reply to the,
yes, because of this,
whatever be the reason, do you want to file or not?
yes, Your Lordship, it would be,
That's what we are asking you.
Nikhil Learned Counsel,
yes, our
Learned Counsel
Or,
for the respondent prays for.
reply may be permitted to be filed, Your Lordship, a response.
Learned Counsel for the respondent prays for and granted time to file counter to the additional affidavit filed on behalf of the applicant. List after 10 days.
Sure.
10 days?
Item 9.
10 days. Delay 10 days. 19 days. 19. 10 days.
Maybe lordship, lordship matter maybe pass over timing lordship.
For what? Delay condonation application, 10 days delay.
My senior is like in report number two.
Notice of the IA number so and so, returnable so and so.
Okay.
Item 10.
But if the in this case, the lots of the original lead petitioner was the Jiten Borua, so now the appellant is the daughter of Jiten Borua, original lead petitioner. Most of them, the fact of the case is that, the fact of the case is,
Your father has already received the due amount and gave a undertaking that no dues are there.
let's see, actually, what they have done. I approached the,
And
High-
there was some-
I approached the Honorable High Court for non-releasing of that fund earlier also. There is an order, annexed, I am annexed. The lordship,
The Lanet single judge
period-
has noted all those things, sir.
Yes.
There was a 5 lakh odd amount was due, 5,92,000 something amount was due. And they paid you 2,22,000.
Let's see, the period of,
House building advance was
Yes, but-
2,22,000 and 3,66,000
I-
they have already paid.
I agree on that.
And
Lordship,
you have given an undertaking, your father has given an undertaking, no further dues are there.
Lordship, actually what happened, Lordship, the unauthorized absence from 1/6/2003 to 31/3/2006, this unauthorized absence was,
Fine.
according to them. Actually, no, there is no,
Sir, there was an
No.
adjudication that 5,92,000 amount was due to
Yes.
you, out of which there was some loan of around 2 lakh or something rupees. After deducting that, they have paid you and your father has accepted it.
Actually, the lordship, the total amount was payable to me was 12,46,200.
So that was already adjudicated by the court. That was already adjudicated by the court.
Whether there is any evidence of the undertaking or not, this is also a matter of lordship.
So that is the
that-
Lanet single judge has observed that
It was
either
not-
show us that no such undertaking was there. This is where the Lanet single, there is a finding of the Lanet single judge.
Lordship, may kindly see there is no any signature in the first page of the undertaking.
Sir, what is this? How can it be?
There is there,
That can't
it is the, there is any evidence in the eye of law that is
Since
also-
your father has died now, your father has not raised any such claim during his lifetime. Whether he has raised any such claim?
Yes, Lordship,
Mr. Counsel, his father during his lifetime has raised this claim regarding it.
No, there was nothing like that, Lordship. These are all afterthoughts.
no, no,
These grounds were not taken in the writ petition at all, Lordship. There was no pleading at all.
Lordship,
That there has to be some show cause notice, there has to be some penalty. There was no pleadings at all, Lordship. Now they have taken all these.
Lordship, speaking what was passed after receiving the earlier petition of my father.
Sir, that was
That
a,
is-
there was a
yes.
contempt also.
The Honorable High Court, in that petition, direction was given to
So
release
the
the.
amount, whatever the amount, 5,92,000 was adjudicated earlier, and this was the amount which was due to you. But since there was a loan, house building advance, and that was deducted, what's wrong in that?
After deducting this 12,46,223.
The 12,46,000, your
Yes.
amount, but
I received 3,66,523 by check.
sir, that is
Then
wrong. You
another
are
loan-
saying, if you are saying 12 lakhs, it was 5,92,000. That's all. It was adjudicated in the earlier contempt proceedings also, and nothing. So now you can't change the stand and say that much of money was amount. Why your father not raised this objection at that time, sir?
Lordship, that is why he approached the High Court also. That the High Court order is there.
That's why the High Court had adjudicated that and
Yes,
found
Lordship.
that 5,92,000 was due.
The High Court or the Honorable High Court has reflected one statement that there is no any notice issued to the to my father regarding that unauthorized absence. No proceeding was
That
initiated
is-
against me.
we are not here for that, deciding that, sir. The Lanet single judge, you approach the Lanet single judge, the due amount has not been paid. Lanet single judge adjudicated that has been paid, that's all.
So what do you-
Like, nothing, like this. Writ appeal is filed by the appellant being agreed with the order dated 1/6/2023 passed by the learned single judge in writ petition number 1451/2013, full stop. The petitioner has approached, the appellant has approached approached this court by way of filing the above writ petition with the prayer. Writ petition with the prayer to direct the respondents to pay the due amount of the arrears to his father, who was expired. His father, who was the employee,
Lordship,
who was the employee of
Powerloom, Assam Powerloom
Assam Powerloom Development Corporation Limited, full stop. It appears that in earlier litigation, the court has issued a direction, earlier litigation initiated at the instance of the father of the appellant. The court has directed, this court has issued direction for payment of the due, for payment of the arrears to the father of the applicant, full stop. Later on, in those proceedings, it was adjudicated that a amount of rupees 5,92,550 was to be paid to the father of the appellant, full stop. The learned single judge has observed that after deducting the house building advance as well as interest charges on the house, interest charges, a total amount of rupees 3,66,523 was paid to the father of the appellant, and he has furnished an undertaking on 15/5/2012 that he had no other entitlement from the said respondent corporation, full stop. The learned single judge observed that once his father has received the amount without any demur, the filing of the filing of the writ petition by the petitioner is misconceived and therefore is not liable to be interfered with, full stop. Having gone through the impugned order as well as the material available on record, we don't find any illegality in the impugned order passed by the learned single judge. Hence, this writ appeal is dismissed.
Obliged.